Hi everyone, my name is Lauren Burns and I'm an attorney at SJF Law Group where we practice estate planning, probate, trust administration, and guardianship law out of our firm in South Florida. I was shocked to hear that only half of Florida residents have an estate plan. People neglect to think about their estate planning for a number of different reasons, and there are a lot of myths and misconceptions about what estate planning is and what it does. And these misunderstandings can oftentimes lead to unintended consequences, create costs on your estate and your beneficiaries, and these misunderstandings about estate planning can oftentimes lead to unintended consequences, waste your time and your money, and ultimately create all kinds of disputes. So we're going to break down some of those myths and misconceptions in this video here today. But before we get started, let's talk a little bit about what estate planning is. Putting a plan in place to protect you, your family, and your loved ones, and your assets if you pass away or become incapacitated. Some documents you'll see as part of a comprehensive estate plan include a will, a trust, durable power of attorney, designation of healthcare surrogate, and a living will. Our first myth today is that estate planning is only for old people, and this is not true. You never know what's going to happen. And emergencies happen, accidents happen all the time. And while that's uncomfortable to think about, the reality is we don't have a crystal ball and we can't predict the future. And estate planning is not just about death, it's also about incapacity. Who do you want to make decisions for you if you can't make them yourself with respect to healthcare and financial decisions? I work with a lot of clients who have children who are turning 18 and going to school or starting jobs, and once that child turns 18 and reaches the age of majority, estate planning becomes really important, because if something, God forbid, happens to that child, their parent no longer has legal authority to make decisions for them. They've now become an adult and they have privacy rights, they can legally contract. So estate planning is for everybody 18 or older, and not something that you should think about later in life, something you should think about sooner rather than later. A lot of times it's a key or major life event that makes someone think about their estate planning, whether it's getting married or having kids, maybe going through a divorce. But the best time to do your estate planning is as soon as possible. When you're young, when you're healthy, when you know that the decisions that you're making are the decisions that you want to make. The best time to do your estate planning is as soon as possible. When you're young, when you're healthy, and when you can make the right decisions for yourself. Second myth is that estate planning is only for wealthy people or people who are rich, which is not the case either. A lot of times when people hear the word estate, they think of having assets that are really valuable or really complex. And your estate doesn't have to be a huge estate for you to do your estate planning. Even if you have a modest estate planning is all about making sure that your assets pass to your beneficiaries according to your wishes. So even if you own a bank account and that's it, you have an estate. Another misconception that we hear all the time is that I'm married, so my spouse will take care of everything if something happens to me, or I have adult children, so they'll be able to step in if something happens. And the truth is that's not the case. Even between married couples, spouses don't automatically have rights to make decisions with respect to healthcare and financial decisions for their spouse. You need something in writing authorizing someone to act on your behalf if you can't communicate or decide for yourself. Another misconception is that people think that if they're married, their spouse will automatically inherit everything, and that's not the case with blended families, where you have a marriage that involves children from prior relationships. The Florida law is very clear on this, and not everything passes 100% to the spouse. So you need to be very careful there with your planning when you have a different family dynamic. Another myth is that you can use power of attorney after someone passes away. And that's common, we hear that often, but power of attorney is a document where you name someone to step in and help you if you can't make decisions about finances. This person helps you pay bills, talks to insurance companies, talks to the IRS, helps with your financial affairs. So, and after death. This next misconception is something that we hear all the time, and that is, oh, I have a will, so I my estate won't need to go through probate. And that is completely false. That's actually the opposite. Your will only controls the probate process. And whether something will need to go through probate upon your death depends on how that asset is titled and whether it names a beneficiary. So the will doesn't keep you out of probate. It only controls the probate process and how assets that go through probate are distributed. This next myth is whether you can do your own will online. And while you, yes, can do your own will online, it's not the best idea. These generic online templates that you see with wills and estate plans don't comply. These online generic templates that you see for wills and estate plans usually don't comply with Florida law, and so you may be creating a document that you think is valid and it's actually not valid, or it does something that is not allowed or prohibited, or doesn't take into consideration some restrictions, especially with homestead property in Florida. So while you can do your own will online, it's not a good idea. Sometimes doing your own will can cost more on your beneficiaries and your estate to fix. When you work with an attorney, you are working with someone who has experience and knowledge in dealing with other situations that are similar to yours. And you're getting the experience that this attorney has developed over the course of their career. When you work with an attorney, you're getting a customized plan that is particular to your situation and your facts and circumstances, and not a one-size-fits-all. Our very last myth and misconception is that once you have your estate plan done and signed, you're done. There's nothing else that you need to do. And the truth is that estate planning is an ongoing process. It's something that you should regularly check in with to make sure that what you've planned for still aligns with your wishes and your intent. Things happen, you change your mind, your kids grow up, things happen. Circumstances in life change, you accumulate more wealth, maybe your circumstances are different. Things happen, you change your mind, circumstances in life change, so you always want to make sure that your documents match where you are in your life. I hope this video has been helpful and has helped clarify some common misconceptions and myths about estate planning. If any of these reasons have been a reason for you on why you haven't moved forward with your estate planning or haven't taken steps to think about it, please give us a call, schedule a consultation with me or one of our other attorneys, and we're happy to walk you through the process and make this as simple as possible for you.